All right, good morning, everyone. We're here on docket 24 CR 09836. This is the matter of State of Vermont versus Peters. We have present on behalf of the State of Vermont, State's Attorney Gerhard. We have Attorney Williams standing in on behalf of the defendant. Defendant is joining us virtually from Northeast Regional Correctional Facility, and your judicial officer joining you from Orleans County this morning. So, Attorney Williams, are you in receipt of the indictment that was returned in this matter?
Yes, Judge, if you can just hold on a minute. The court volume here is kind of poor. We're trying to turn it up.
All right, just let me know when you're ready to proceed.
It's still low. Good morning, Your Honor.
Good morning.
All right, I think we've gotten a solution. Yes, Judge, we're in receipt of the indictment. We would waive the reading, other Rule 5 rights, and enter a not guilty plea.
All right, noting the not guilty plea state, or what are your requests today?
Your Honor, the state is requesting the defendant be held without bail. He is charged with murder one, which is the most serious crime in the state of Vermont. Has a life sentence, and so it is a presumption that he be imprisoned. So that is what the state is requesting.
All right, Attorney Williams.
Judge, we would argue for release on conditions. The offense allegation is from just over 31 years ago. Mr. Peters has remained in the community that entire time. He has not been charged with any offenses that are from after that date. He owns a home on Fitch Hill Road that he's had for over 20 years. He runs a business that he and his son do land surveying work. He's done that for decades. He has 3 children in the area, so we don't believe he's any risk of flight. Furthermore, to hold without bail, the court needs to be doing an evaluation of the weight of the evidence. And right now, because this was done through an indictment, there's no supporting affidavit or a PC affidavit that's been filed with the court. So I would argue that the court is unable to do a sufficient evaluation of the weight of the evidence or the particulars to be able to hold Mr. Peters without bail.
Your Honor, may I respond?
Yeah.
Thank you. First of all, this was a grand jury indictment. It was a community. The community found him that there was probable cause to indict him for murder in the first degree. The fact that this is an old case should not be held against the state, should not be held against the victim. The defendant also, in his criminal record, was convicted of a sex assault against a type of sexual assault offense against the same victim prior to her homicide. The risk of flight in the state's mind is great. He has now been charged with murder one as opposed to just laying low in the community for 31 years uncharged. There is case law, State versus Eau Claire, and there is other case law that supports the notion that there is a completely different standard when a defendant has been charged with a crime, especially a life imprisonment crime. He has a home in Florida that he owns, and so he is a huge risk of flight. And Your Honor, this was an execution-style killing when the victim was sleeping. This was her estranged husband of 3 years who stalked her over the course of months when she tried to leave and then executed her 2 days before she planned to move away to Montpelier to get away from him. This defendant sent her hundreds of letters over the course of their separation. He was found outside her windows when she was living with various family members after the separation. This man is a danger, and I would ask Your Honor not to let his age or his current appearance change Your Honor's, alter Your Honor's decision.
And Judge, I would just counter that the defendant was charged with sexual assault, as the state mentioned. Those were eventually pled out as 2 misdemeanor prohibited acts, but those cases were pending for quite a long time prior to that occurring. I'm not aware of any risk of or any arrest warrants that occurred during that time or non-appearance. He's never been charged with failing to appear, and his record check notes no failures to appear on his record, even when he was being charged with 2 counts of sexual assault. The state may have just alleged a number of facts. However, there's no affidavit or other evidence in front of the court showing that any of those are based upon admissible evidence at this point. The information that was presented to a grand jury may be something that becomes public at this time. However, we don't know whether or not that was based upon hearsay or if it was admissible evidence that could be used against the defendant going forward. So we would argue that the court's not in a position to find anything about the weight of the evidence independent of just simply a grand jury indictment.
And Your Honor, the state welcomes the weight of the evidence hearing to be heard where the state can present more evidence in support of the indictment.
All right, so let me ask this question. How soon would the state be prepared to proceed with the weight of the evidence hearing if the court were inclined to hold the defendant without bail?
We could proceed next week, Your Honor.
Right. Right, so first the court will note that pursuant to 13 VSA 7553, a defendant may be held without bail in a circumstance or a case where a life offense has been alleged. Here, the defendant is charged with a first-degree murder, which would satisfy the initial statutory requirement to exercise the court's discretion to hold a defendant without bail. This is a somewhat unique procedural posture. I'm sure, as the parties are aware, a grand jury is seldom convened in the state of Vermont, and the posture here is somewhat different. With that said, the court recognizes that in order for a true bill to have been returned, the state would have been required to produce a substantial volume of evidence to demonstrate that there is probable cause for the case. While the court has not had an opportunity to independently review those materials, the fact that there was a true bill signifies some quantum of evidence in support of guilt at this point in time, or at least for finding a probable cause. With that being said, the court declines to exercise discretion to release the defendant at this time. We will allow for the state to put on its evidence at a weight of the evidence hearing. The defendant shall remain held without bail pending a weight of the evidence hearing, which will defer to the memorial unit to schedule next week. Court noting from the record, as the defense counsel cited, the defendant has a very limited criminal record. It appears to be misdemeanor convictions dating back almost 23 or 24 years. That said, there's no history of a failure to appear. However, the court does have concerns given the nature and allegations of the offense, the proffer of the state as to the nature and violence of the offense, and moreover, despite there being business and or familial ties to the state, it does sound as though the defendant has at least some ties or property outside of the state of Vermont. Additionally, the fact that he owns his own home, has a business, may suggest the ability of cash or other resources that may contribute to a risk of flight. In the absence of additional information, the court feels that the state has met a minimum threshold to at least make it to a weight of the evidence hearing where a judicial officer can consider the greater volume of evidence, both as it relates to whether the evidence of guilt is great, and additionally, whether there is a sufficient basis to exercise the court's discretion to release the defendant subject to conditions or a combination of conditions and or bail. State recognizing that the court is going to maintain the hold without bail order issued after hours. Were there any other requested conditions or no contact with any individuals or anything like that, or is the order to hold sufficient at this point?
Yes, Your Honor. Just at this point, we would ask no contact with the victim's family.
Do you have specific names or initials that can go into an order?
Yes, Your Honor. T and RP.
So that's TT and MRP?
RP, Your Honor.
RP,
Thank
okay.
you. Sorry, it's echoing.
All right, Attorney Williams, understanding that's fairly limited information, do you or your client have any idea of who those individuals are, what those initials?
And I can share that with Mr. Williams.
Judge, they're adults. I see no reason for them not to be named, just to add specificity.
I'm just concerned because this is a very high-profile case.
All right, well, the defendant is entitled to have adequate notice of who it is he's not supposed to have contact with, so we can take their names, please.
Sure. It's Tina Teal and Ray Marie Pecor.
No objection, Judge.
All right, so the defendant will also have the following condition of release imposed: that he must not knowingly initiate or maintain contact with Tina Teal arraignment PCOR, which includes in-person, in writing, by telephone, by electronic communication, including through social media, text, or email, or through a third person, regardless of whether he is in jail or released. This applies even if the protected person initiates contact.
Thank you, Your Honor.
All right, so again, we'll defer to the Memorial Unit for scheduling of the weight of the evidence hearing. State, do you have an estimate of how much time you believe you would need to present your evidence?
How much time we would need? About 2 hours, Your Honor.
All right, so we'll look to get a 2-hour hearing scheduled in this matter. Anything further that we can take up today?
Judge, I would just ask for a provisional public defender assignment, and then Mr. Peters could submit a public defender application, but given the posture of the case and the potential for a quick turnaround and weight of the evidence, I'd ask for provisional appointment.
All right, so the court will, for the time being, assign Attorney Williams as counsel of record in this matter. However, Mr. Peters, the court's going to ask that today you work with the case manager at the facility to complete a public defender application. If you qualify for public defender services, the court will react and formally assign counsel. Otherwise, we'll have to have a discussion at some point in time about your options for representation moving forward. Okay? All right. So thank you very much. That'll conclude the matter of State of Vermont versus Peters.
Thank you, Your Honor.
Thank you.